So what are your options in court after being charged with a drug offence? For a drug charge, you have one of two options in court. You can either plead guilty or not guilty to the charge. If you plead not guilty, your case will eventually get adjourned to a defendant hearing in the local court or trial in the district court after all the evidence is served. A magistrate or jury will then decide whether you're guilty or not guilty after all the evidence is given in court by both the prosecution and defence. You'll be acquitted and the charge will be dismissed if you're found not guilty. You'll be sentenced if you're found guilty in court. If you plead guilty, your case will proceed to sentence where the magistrate or judge will impose a penalty. It's very important to be well prepared for your sentence to maximise your chances of getting the best possible sentence outcome possible. This includes preparing any necessary documents such as a psychologist report, character reference letters, which can help convince the judge to impose a more lenient sentence. By pleading guilty at the earliest time possible in the case, the sentence will be discounted by up to 25%, leading to a much better outcome. In New South Wales, it's a crime to supply, import, possess, cultivate, manufacture prohibited drugs, or step into or use drug premises. A prohibited drug or a border-controlled drug includes MDMA, ecstasy, cocaine, heroin, methamphetamine, LSD, and amphetamine. A complete list is outlined in Schedule 1 of the Drug Misuse and Trafficking Act 1985, New South Wales. So what are the penalties for drug offences in New South Wales? The penalties or sentences for drug offences in New South Wales vary from a non-conviction Section 10 to life imprisonment. The maximum penalties for drug offences range from 2 years and or $5,500 fine to life imprisonment and or $550,000 fine. These penalties vary depending on the type of prohibited drug, its weight category, purity of the drug, role or level of participation, extent of planning and sophistication, whether you did it for a greed or a need, and your prospects of rehabilitation, including any expressions of your insight, remorse for committing the crime. Some prohibited drugs have different weight categories while others have the same, which will usually affect the ultimate sentence outcome. As a general rule of thumb, the higher the weight category is, the higher the penalty is likely to be. For example, for drug supply offences, amphetamine, methamphetamine, cocaine and heroin each have a small quantity of 1 gram, trafficable quantity of 3 grams, indictable quantity of 5 grams, commercial quantity of 250 grams and large commercial quantity of 1 kilogram. MDMA or ecstasy, on the other hand, has a small quantity of 0.25 grams, trafficable quantity of 0.75 grams, indictable quantity of 1.25 grams, commercial quantity of 125 grams, and a large commercial quantity of 500 grams. In the case of drug importation, the weight categories also vary depending on the drug, ranging from marketable quantity to commercial quantity. As for cultivating cannabis plants, you'll face the same maximum penalty for cultivating 50 cannabis plants indoors to if you cultivate 999 cannabis plants outdoors. As from the end of January 2019 in New South Wales, police can now issue on-the-spot fines without the requirements to appear in court to anyone caught with small amounts of drugs in certain circumstances. A criminal conviction can be avoided for a drug offence, even after pleading guilty if the court can be convinced to impose a Section 10 non-conviction sentence. So how do you beat a drug charge, or how do you get a drug charge dropped? Either the court will find you not guilty or your drug charge will get dropped early if any of the following defences to drug charges apply. The prosecution is unable to prove each of the essential elements of the drug charge beyond reasonable doubt. The drugs were found by police as a result of something improper or illegal done by the police, such as an illegal search or an arrest. You weren't aware of the drug's existence where it was found. The drugs were found in a common area frequented by others, or you committed the offence due to duress or necessity. If any such defence applies to a drug charge, an experienced drug lawyer can begin to negotiate with the prosecution to try to get the charges dropped early. For more information on the law, defences and penalties for drug charges, either browse through this page or simply call our 24/7 hotline to arrange a free consultation with one of our drug lawyers today.